This case, number 25-D CCR-1759, was heard before a judge in what appears to be a Texas State District Court. The defendant, Hayden Fontanet, had previously entered a plea of guilty to the first-degree felony offense of aggravated robbery. Critically, this was an unagreed plea, meaning there was no plea bargain between the prosecution and the defense on the sentence. Mr. Fontanet was pleading guilty and placing himself entirely at the mercy of the court for sentencing. He was represented by defense attorney Mr. Rojas, and the state was represented by prosecutor Mr. Coleman. The court had received and reviewed the pre-sentence investigation report, and both parties had the opportunity to present evidence and argument before the judge rendered sentence. Under Texas law, aggravated robbery is defined in Texas Penal Code Section 29.03 as a robbery committed while the defendant uses or exhibits a deadly weapon, or causes serious bodily injury to another person, or places a person in fear of imminent serious bodily injury or death. It is classified as a first-degree felony, which under Texas Penal Code Section 12.32 carries a punishment range of 5 to 99 years, or life in prison, along with a fine of up to $10,000. The fact that this was an unagreed plea meant the judge had the full statutory range available, from the minimum of 5 years to the maximum of 99 years or life, and neither party had any binding agreement restricting that range. This is a high-risk strategy for any defendant, particularly one facing a first-degree felony, because the outcome depends entirely on the judge's assessment of the evidence, the pre-sentence report, and the arguments presented at sentencing.
Hayden Fontanet, Mr. Rojas, at the sentencing. Good morning. Are you Hayden
Yes.
Fontanet? And this is 25 DCCR 1759. Mr. Fontanet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. The state has, Judge.
Are there any additions or corrections to the report?
Not from the defense, not from the state, Judge.
And Mr. Coleman, you said you have a witness or some evidence.
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. So
Okay.
I need to call my custodian record. With the court's permission, first of all, I'm offering states one. No, Judge.
Make that states two, because this one was the plea admonishment
Okay.
documentation, please.
I'm offering states two. No objection.
States two is admitted.
Permission to publish, Judge.
Yes, sir.
Judge, I think that's all I wish to publish unless the court wants to see the entirety of the video.
But I think that's enough. Any other evidence or witnesses?
So just brief argument if I may.
Any other evidence or witnesses for Mr. Rojas?
No, Your Honor, just like,
Mr. Rojas, you may make argument first.
thank
Go
you,
ahead.
Judge. And obviously, after seeing that video, it makes what we're asking for harder to do. What we're here asking for this morning, Judge, is probation. Mr. Fontanet, he is a young offender. I know the court is tired of hearing the same story over and over again, young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom out at home, trying to pay some bills, keep the lights on. Certainly, there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontanet that. We've got options here, Judge. We can send him to prison or we can put him on probation. Certainly, he's on the road if this conduct continues, he's on the road with prison. I don't know that the day is the best time to make that exit for him. He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer. Because there'd be one less guy running around with a gun when he does get out of prison, if that were the road that you chose to take. Planning on living at home with his mom. I think he has some younger siblings there. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery. Again, Judge, you've got two options. You can send him to prison, or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly if he doesn't, we're going to know pretty quick, and you'll have another chance to send him to prison probably for a longer time.
All right, thank you. What is the status of the other two? Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Prosecutor Coleman's argument was direct, impassioned, and focused squarely on community safety. He told the judge that prayer vigils and advisory committees were fine, but that the judge was where the rubber meets the road, the one person who could protect the community from defendants like Mr. Fontenette. He characterized the choice starkly: either let the defendant walk out on probation with a piece of paper and promises, or ensure community safety by placing him behind steel bars, concrete walls, and razor wire. Coleman stated that he was not in the habit of begging, but that on behalf of the community, the residents of Pine Club Apartments who want to live in peace, the people who want to walk in Rogers Park without being robbed, and those who want to stop at a convenience store without becoming victims, he was begging the court to impose a prison sentence. He argued that the message needed to be sent that picking up a gun with the intent to commit violence means picking up a 15, 20, or 25-year prison sentence. The prosecution's emphasis on deterrence reflects one of the four recognized purposes of criminal sentencing: deterrence, incapacitation, rehabilitation, and retribution. Under Texas sentencing law, the court has broad discretion to weigh these factors. The pre-sentence investigation report, required under Texas Code of Criminal Procedure Article 42, A.252, provides the court with a comprehensive assessment of the defendant's background, criminal history, risk level, and likelihood of success on community supervision. In Mr. Fontenette's case, that report classified him as a high-risk offender, which directly undermined the defense's argument for probation and supported the prosecution's position that incapacitation was necessary to protect the community.
Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all that stuff's fine, but you, Judge, are where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. You are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. I'm just asking, I'm not in the habit of begging, but on behalf of this community, I'm begging that you send this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're gonna pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club Apartments, who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery. That's all I have, Judge.
Thank you, Mr. Coleman. So, Mr. Fontenette, there was a time some years ago that there really wasn't even a question. State's attorneys were recommending youthful offenders, probation. Let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that person had that was working in that store, that he now has, just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division.
Come on, Mom. Here.
I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontenette, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better. That's going to be up to you, okay? You can go back with the bailiff.
The judge sentenced Hayden Fontenette to 25 years in the institutional division of the Texas Department of Criminal Justice. The court made an affirmative finding of a deadly weapon, which under Texas law has significant implications for parole eligibility. Under Texas Government Code Section 508.145D, when a deadly weapon finding is made, the defendant is not eligible for parole until he has served at least half of his sentence, or 30 calendar years, whichever is less, without consideration of good conduct time for parole purposes. This means Mr. Fontenette will not be eligible for parole until he has served a minimum of 12.5 years of actual calendar time. The judge also informed him of his ineligibility to possess firearms or ammunition under Texas law as a result of the felony conviction. Before imposing the sentence, the judge explained her reasoning with notable candor. She acknowledged that there was a time, not long ago, when youthful offenders were routinely recommended for probation and given second chances. But she stated that circumstances had changed in an incredibly dangerous way, pointing to the surveillance video that showed Mr. Fontenette and two co-defendants not simply grabbing merchandise and running, but terrorizing a store employee for an extended period, pulling him around, yanking him, and putting guns in his face. She also referenced jail incident reports showing that Mr. Fontenette had been involved in fights and had jumped other inmates while awaiting sentencing, conduct that directly contradicted the defense's argument that he was ready to follow rules and succeed on probation. The judge stated that the pre-sentence report classified him as high risk, meaning the professional assessment was that he had a poor likelihood of success on community supervision. This case encapsulates one of the most difficult balancing acts in the criminal justice system, the tension between rehabilitation and public safety, particularly when the defendant is young. Mr. Fontenette's defense attorney made a compelling argument that prison would not fix the underlying problems: the lack of direction, the absence of support at home, the desperation that led a young man to commit a violent crime. Those are real systemic issues that prison alone does not address. But the prosecution's argument was equally compelling. The community has a right to be safe, and a person who terrorizes a store clerk at gunpoint, who is classified as high risk by professional evaluators, and who cannot even refrain from violence while incarcerated awaiting sentencing, has demonstrated that he is not a candidate for the trust that probation requires. The judge addressed Mr. Fontenette directly after sentencing, telling him she understood the sentence was harsh, that she knew he believed it was harsh, but that she believed it was necessary. She told him he could still make his life better, that he would get out of prison while still young, and would have the opportunity to turn things around. That acknowledgement that this sentence is not the end of his story is an important statement from the bench. 25 years is a devastating sentence for a young man, but the conduct that earned it, terrorizing a human being at gunpoint for an extended period of time in concert with two other armed individuals, is conduct that the justice system cannot treat as a youthful indiscretion to be resolved with conditions and promises. At some point, the severity of the crime and the risk to the community outweigh the defendant's youth and potential, and the court must prioritize the safety of the people it serves. That is what happened here. Let us know if there is a case or legal topic you'd like us to cover next.